and Session Judge, UP Judicial Service, and Advocate Ajay Kumar Yadav ji from District and Session Court, Gorakhpur. Sir, we are grateful for your valuable time that we get to share with you, not wasting so much time. I again welcome all of you at this event. Thank you, sir. Over to you, Samvi.
Thank you so much, sir. I again welcome all our chief guests for today's event. Now we shall begin with our first session. For the same, I'd like to invite our first speaker, Professor N.K. Behl, sir, to grace us with his knowledgeable insight on the above said subject of criminal law. Sir, the stage is all yours.
Thank you, Shambhavi. Please unmute.
Sorry, sir?
I am muted.
Okay, wait, sir. I'm doing it.
Yes, Honorable the Chairman, JEMTEC School of Law, Dr. Amit Gupta ji, Campus Director, Dr. R.K. Raghuvanshi, sir, Principal, JEMTEC School of Law, Greater Noida, Dr. Pallavi Gupta ma'am, our faculty coordinators for the day, Mr. Sudhir Dwivedi and Ms. Priyadarshini Tiwari, student coordinators, Shivam Tiwari and Saurabh Guha, and moderator Shambhavi Singh. Thank you very much for inviting me to this symposium. First of all, I welcome my dear brother Ajay Kumar Yadav, advocate from Gorakhpur. Most welcome to JEMTEC School of Law, sir. Dear students, today's topic is sentencing policy. First of all, I would like to tell you at what stage this sentencing policy is implemented. You know, in criminal side, the law can be set into motion either by lodging an FIR at the police station under whose jurisdiction the crime was committed, or by filing a complaint case directly in the court of competent judicial magistrate. So the moment FIR is lodged, investigation starts. And as you know that investigation results either into filing of charge sheet or filing of a final report that no case is made out. Then second stage of criminal proceedings start, that is inquiry. And inquiry results either into framing of charge or discharge of the accused. Once the accused is not discharged, then after framing of the charge, the trial takes place. And it is at the end of the trial when both the parties have led their evidence. At the stage of arguments, the question of sentencing policy is also argued before the court. And it is for the judge or magistrate concerned while dictating a judgment that he will have to keep sentencing policy in mind as to how much amount of punishment he is going to award. So trial is the third stage of criminal proceeding, which results either in acquittal or conviction. But once the accused is found guilty, there is a provision in the CRPC that he has to be given a separate hearing on sentencing. In warrant trials as well as in the session trial, there is a compulsory provision. If you see session trial, then section 235 clause 2 CRPC is there. And in both the kinds of warrant trials, section 248 clause 2 is there, where a special hearing is given to the accused as to how much sentence should be imposed on him. So this is the stage when the question of sentencing policy comes into question, because a separate hearing is to be given to the accused. This separate hearing is not required in summons trial and summary trials because the matters are very small. But in serious matters, all warrant trials and session trials, a separate hearing is to be given to the accused or his counsel, keeping in mind the sentencing policy. Now, dear students, I would like to tell you that sentencing policy depends upon the mind of the judge, what he has in his mind. If he is keeping a deterrent theory of punishment at the back of the mind, then sentencing policy will be different. If he is keeping preventive theory of mind, preventive theory of punishment at the back of his mind, then of course his policy would be different. And if he is keeping retributive theory of punishment, again the policy will be different. And if he is a reformative judge, he is keeping rehabilitative theory of punishment at the back of his mind, then again the sentencing policy would be different. Dear students, sentencing also involves the alternate sentences also. The judge may release an accused on mere admonition also, according to section 360 of CRPC, or the accused may be released on probation, under probation of Offenders Act 1960 in appropriate cases. And dear students, you must have read in the newspaper the latest bail order passed by Honorable Supreme Court in Gautam Navalekha's case. Honorable Supreme Court has given an obiter that during pendency of the trial, the judicial magistrate may consider releasing the accused on house arrest if he is not inclined to grant bail. Then instead of sending the person to jail, he may be kept under house arrest. And for post-conviction cases, the Honorable Supreme Court has left it to the discretion of the legislature to pass a law whether post-conviction cases also a person can be ordered to stay at home under house arrest instead of going to jail. So this is a great indication and a turning point so far as sentencing policy in India is concerned. Dear students, when I was practicing as an advocate at Dehradun, right back I'm talking of 1981 or 82, then as an advocate, once I posed this question to one of the judges posted at Dehradun. Later on, that honorable judge was elevated as an high court judge also. I asked him, sir, how do you impose the sentence on a particular accused? What is the policy in your mind? How do you pass sentence order once the accused is found guilty? So that judge very nicely explained me what is sentencing policy and how the judge awards a sentence to a convicted person. He explained me and gave an illustration of theft. Simple theft, defined under section 378 IPC, punishable under section 379 IPC, with imprisonment which may extend up to 3 years, or fine, or with both. The judge explained me, suppose a case comes before him where a person has committed theft of peanuts, mungfali ki chori kiya. The judge says that, well, I will award him punishment of say ₹5 because the value of the property involved is also somewhere around ₹5. I said, okay, sir. Then he says, suppose another accused has committed theft of dry fruits from a shop. Then I will award him punishment in theft for 1 hour or 2. A sentence still rising, and the court was over at 4 p.m. So 1 hour sentence is given to the accused, known as TRC, sentence still rising of the court. Then judge explained me that if it was a case of bicycle theft, then maximum punishment he could have awarded is 7 days. I said, okay, sir. And if it is a case of theft of motorcycle, then judge says that I will award him 15 days punishment under same section 379 IPC. Then I said, if it was a case of theft of a car, Then he said to me that I will award 1 month imprisonment under the same section. Then my question was that if it was a loss of household goods, how much punishment will you award? Then judge replied me that 3 months imprisonment will suffice for a theft in a dwelling house. Then I asked him a question that if in the next house, some of the jewelry is also stolen and cash is stolen, or 6 months imprisonment if there is a theft of jewelry and cash from a dwelling house. Then next question was that if an accused commits theft in a silver jewelry shop, several thousand rupees silver ornaments are stolen, how much punishment will a judge award? Then judge replied me that in such cases, imprisonment would be sufficient to meet the ends of justice. Then I said, sir, if had it been a shop of jewelry with golden articles, if the gold was stolen, then its cost went into the lakhs of rupees. Then judge replied that in a case of theft of gold ornaments, I will award 2 years imprisonment under section 379. And my last question as an advocate was, as a student of law, was that, sir, if it was a theft of diamond jewelry from a shop after breaking open the lock of the shutter, how much punishment will you award? Judge said, I will award complete 3 years imprisonment if it was a case of diamond thefts from a shop. So my dear students, we started from a punishment of ₹5, went up to 3 years imprisonment, in between having TRC for 1 or 2 hours, then for bicycle 7 days, motorcycle 15 days, dwelling house theft 3 months, dwelling house theft with the jewelry and cash, punishment 6, silver jewelry shop, punishment 1 year, gold jewelry shop, punishment 2 years, and diamond jewelry shop, theft, punishment. My dear students, this is sentencing policy. The judge has various yardsticks in mind while awarding punishment in the same section. Theft is same. 378 IPC definition of theft is same for all these illustrations. But the amount of punishment awarded by the judge is different according to the value of the property also. Then lastly, I asked the judge a question, sir, all right, you have a maximum limit of 3 years imprisonment so far as theft is concerned. How do you decide from 1 day to 3 years? He replied me, Pahel Sahab, bahut aasan kaam hai. You start from halfway of the punishment. 3 years punishment is there, make it half in your mind, 1.5 years. And then see the mitigating and in aggravating circumstances or increase the punishment. If circumstances are mitigating, reduce the punishment from 1.5 years to lower side. And if these circumstances are aggravating, then increase the punishment from 1.5 years to 3 years, wherever you like and deem fit. So dear student, this is one illustration of sentencing policy I gave you, which will give you the entire idea of sentencing policy from one perspective at least. Then dear students, the sentencing policy depends upon the type of sentence given by the legislature. We have 2 categories of sentences available in our laws. One sentence is indeterminate sentence and second is determinate sentence. So wherever sentence is indeterminate, indeterminate means where law fixes only the maximum penalty and judge has discretion to award maximum punishment from 0 to maximum given under a particular section. If you read IPC, mostly all the sections, they say that imprisonment which may extend to 3 years, which may extend to 10 years, which may extend to 7 years, or like. So this kind of sentence is sentencing. Model is indeterminate. So judge has discretion from, say, let us take the old example of theft. Judge had the discretion of awarding sentence admonition to complete 3 years coupled with fine or not. So here the question of sentencing policy comes. What is the policy in the mind of the judge? How he awards punishment from admonition to years? And there are so many variations in between. And then, dear students, second category of sentencing is determinate sentence, where the sentence is already fixed by the legislature. Judge has no discretion to increase or decrease the punishment. Like if you are found walking on the roadside nowadays without mask in COVID period, then sentence in UP is 1,000 rupees. Neither 999, no, not 1,001. The sentence is fixed 1,000 rupees. Even the police officer who has been given magisterial powers for punishing you on the spot, he has no discretion to reduce the sentence. Likewise, if your matter reaches the court, the concerned judicial magistrate also has no discretion. He cannot reduce the sentence from 1,000 rupees. He cannot increase the sentence from 1,000 rupees. So there is no question of sentencing policy, because this policy is locked by the parliament or the legislature when the law was prepared or drafted. And dear students, this discretion part of the judge, while sentencing or while awarding the punishment, incorporates the doctrine of sentencing ideas in our country. We have seen another section 303 in IPC, where the only penalty is death. All of you have read that if a murder is committed by a person who is already undergoing life imprisonment, then judge has no discretion but to award death penalty. So, as you know, in Mithu versus State, this is the leading case, leading authority, where section 303 of IPC was declared unconstitutional because it did not give any discretion to the judge, any discretion for implementing the sentence while. And there are, in other countries, there is third kind of sentence also known as suspended sentence. A person is awarded 6 months imprisonment for theft, but his sentence will remain suspended. If he commits theft again, then his old sentence will revive. And of course, a new trial for the new theft will be conducted by the competent court. So that suspended sentence, once it is given, is another aspect of sentencing policy, although this suspended sentence is not applicable in our country. So dear students, so far as the sentencing policy and its guidelines are concerned, I may tell you that there are no fixed guidelines for sentencing policy in India. The first item which the judge has in his mind is the character of offense. I gave you example of peanuts theft to diamond theft. So how much punishment is to be awarded? First of all, first guideline is character of the offense, category of the offense, heinousness of the offense. Then second probable factor may be characteristic of the offender. Whether the offender is a first offender, or he has a criminal history behind him, or the offender is a juvenile, then you will have different policy in your mind. Then age of the offender, as I said, juvenile. Health of the convicted person. If a person is 90 years old, he is to be punished. And on the other hand, if a young boy of 20 years is to be punished for the same offense, the quantum of punishment may be different on account of age, health. See, nowadays, Corona was a criteria for bail. Corona infection, on the basis of Corona infection, the parole was granted to so many prisoners from jail. And dear students, the most important guideline while implementing the sentencing policy is the proportionality of the sentence. In our illustration, the judge awarded only ₹5 fine for theft of peanuts and complete 3 years for theft of diamond jewelry. So there is a proportionality of the sentence. This is one aspect of sentencing policy. And your policy must be uniform. If you are applying sentencing policy, you will have to apply it on all offenders, all convicted persons of the same category. And you will have to keep in mind the public safety also. Your sentencing policy should be such that ultimately the interest of the society is protected, and whether the convicted person is a male or female. Simply not be awarded to quantum of punishments may be awarded to male and female. And there is another norm that no death penalty shall be given to a lady who is pregnant. Death penalty shall not be executed if the lady is pregnant, because you are giving death penalty to two persons, one to the lady and secondly to the child in womb. So you will have to keep in mind this aspect of sentencing policy also. Then education, whether the offender is educated or uneducated, whether he is an earning member of the family or non-earning member. And dear students, judges are very intelligent. When a judge has, suppose, convicted a person under theft, while giving the sentence, while having a particular policy of sentencing in mind, he can award him punishment maximum up to 3 years. But if judge has in his mind that accused should be released immediately on bail after conviction, then judge may award him sentence below, so that to file an appeal against conviction order without going to jail. Under section 389 of CRPC, if punishment less than 3 years is awarded, then accused has a right to get bail from the same court which has convicted him. So if judge is of the opinion that this case is a fit for appeal and accused should not be sent to jail immediately, then he will award less than 3 years imprisonment so as to entitle the accused to get bail from the same court under section 389 of CRPC. Then, dear students, manner of committing the offense is another aspect of sentencing as to how the offense was committed. You see the latest example of this cricketer, Mr. Navjot Singh Sidhu. He is member of parliament also. He killed a taxi driver by giving a blow on his face. Supreme Court convicted Mr. Navjot Singh Sidhu with a fine of 1,000 rupees only, although the man has died, victim had died. Only 1,000 rupees fine was imposed under section 304 IPC. So what judges had in mind while not awarding any imprisonment to Mr. Navjot Singh Sidhu, and the maximum penalty which was given is 1,000 rupees. Although state has filed a review application in the Supreme Court for reviewing this judgment of convicting Navjot Singh Sidhu with 1,000 and I where there were only 2 injuries at the lady and she died while falling on the earth. The maximum penalty awarded by Bombay High Court Justice Melville was 7 years transportation for life. On the other hand, you have read a case, State of Andhra Pradesh versus R. Punaya, in which the number of body of the accused were 19, the 304 part second. So dear students, Regina versus Govinda's 2 injuries, punishment 7 year transportation for life. R. Punaya 19 life. The proportionality of the punishment in these 2 cases. Dear students, before I close, I would like to add one more point, that since we have 5 categories of punishment in IPC, if you see section 53, then you will find that the first punishment is death, second is imprisonment for life, third is penal servitude. Penal servitude means imprisonment with hard labor, which has been abolished now. Third is imprisonment which may be simple or rigorous. Fifth one is forfeiture of property, and last one is fine. You know, so far as this punishment has been abolished and substituted with imprisonment for life. There is one illustration of Mr. Vinayak Damodar Sarwarkar. He was awarded 50 years Kala Pani sentence. At that time, it was known as Kala Pani ki saja ho gayi hai. Transportation for life for 50 years for his connections with revolutionary groups. But he was kept in cellular jail of Andaman and Nicobar. But on clemency, he was released in 1921. But now this transportation for life has been abolished. So punishment given to Govinda in R versus Govinda was also 7 years transportation for life, which has now been converted into imprisonment for life. So what I was trying to tell you, dear students, is that if a person has been imprisoned for 14 years in an offense where death is one of the penalty, or if death penalty has been converted into life imprisonment, then minimum amount which he has to serve in jail is 14 years. He cannot be released from the jail, even if he is of very good conduct in the jail and he earns so many remissions. But the minimum period which he has to remain in jail is 14 years. Although simple meaning of imprisonment for life, according to me, is that accused has to breathe last in jail. But this minimum detention of 14 years also affects our sentencing policy indirectly. That a judge has awarded him life imprisonment, but he is released after 14 years. So indirectly, by executive action, this sentencing policy is being affected. And there is another section in IPC 75 which affects the sentencing policy once again. Suppose in a case of theft, a person was awarded 3 years imprisonment. But if he commits the same theft once again, then his punishment shall not be 3 years. It shall be life imprisonment or 10 years. This is another guideline which affects the sentencing policy, because judge has to award the punishment. Judge is the final authority to give the punishment, but legislative directions are very important. So my dear students, I will not touch other aspects of sentencing policy because my learned brother, Mr. Ajay Kumar, is going to deliver his expert lecture on sentencing policy. So I have not covered those points which my brother colleague Ajay Kumar Yadav ji would be covering. So thank you very much. Over to moderator Shambhavi again.
Thank you so much, sir, for such an insightful and interesting outlook to the subject of sentencing policy. Thank you, sir. Thank you so much. Whoever has any questions regarding the if you want to
Yeah.
ask any questions, you can.
Yeah, questions are welcome.
Or you can write down the questions in the
we
chat
can
box.
take the question in the last of the event.
Yeah, it would
sure,
be
sir.
better to
Yes,
take the questions at the
Yes.
end.
yes, sir. Okay. So now I'd like to welcome the Advocate Ajay Kumar Yadav, sir, to please begin this session with your insightful understanding on the subject of sentencing policy. Over to you, sir. Sir, we can't hear you, sir. No, sir, you're not audible. Sir, you're still not audible.
Hello.
Yes, sir, now it's
Am I-
audible, sir.
Okay. Hello.
Yes, sir, you're audible now.
Okay, thank you. Thank you, sir. Thank you, ma'am. First of all, I would like to express my gratitude to Professor Pallavi Gupta, Principal, JEMTEC School of Law. Thank you for inviting me, ma'am. And I would like to thanks to Ms. Priyadarshini Tiwari and Mr. Sudhir Agrawal for coordinating me. Hello, am I audible? Hello.
Yes, sir, you are.
Yes, sir, you are audible.
Okay. Thank you. As respected sir has told very nicely all the things they covered very nicely, and as an advocate I would like to focus on the very practical issues of the sentencing procedure, how a trial will start in the commission of the after the commission of the crime, and how it will go to the stage of sentencing. First of all, suppose when an offense is committed in the society, first of all, what things comes into the existence? We all know that FIR comes into the existence. FIR comes into the existence. FIR the initiation of criminal law, just as sir has told, that it may be started either through the FIR or through the complaint case. But I will here only talk about the FIR cases. When the FIR laws in the police station, the police register the FIR, and they have two options. Either when if the offender who has committed the crime is available on the spot, the one situation, and the second one is if he ran away from the spot and the police cannot caught him. This is the second situation. In both the situation, the proceedings are different. We will talk one by one. The first situation, when the offender ran away from the occurring places, and he cannot be caught by the police. In this situation, what the police will do? The first of all, the police will go to the court and talk and will pray for the remand of the judicial custody under section 167 of the CRPC. Then now during this period, the investigation process is going on, and the police shall record the evidences of the witnesses, complainant, and all the persons who are acquainted with the fact and circumstances of the case. Now, after under section 167, when he obtain the remand, I'm sorry, he will NBW. He will call for NBW, non-available warrant, that the person who has committed the crime is not in the purview of that particular police station, or he is not in the position to be captured. Then he will go to the. He will means the police officer will go to the proceeding of section 82 of the CRPC, in which he will shall declare him the absconded. After the declaration of the absconding, he will given some time to be appear before the court. If after that period he does not even after that period he does not appear before the court, the court shall issue the police shall file the case of section 174A for non-compliance of section 82 of the CRPC, and even in that case, he will proceed with the section of section 83, in which he shall order for the attachment of the property of the accused. These all process are only for the appearance of the accused, not for any other else. If he does not appear properly, these all the situation will come into the existence. The second thing is, here the investigation is going on. When the police completed its investigation, it shall file the charge sheet before the magistrate. Magistrate shall take the cognizance of that particular case. After seeing the charge sheet of that particular matter, the magistrate shall frame the cases, frame the charge, and after this situation, the process of trial will be start, and the commencement of the APO or PP shall come here into the existence. Now the APO or PP or state council will record the examination chief, and then after the matter shall be forwarded under section 313, and there will be put to the question before the accused that these are the allegation upon you, and you have committed these and these crimes. These are the evidences against you. What do you want to say about this? If the accused says nothing, then the proceeding will be closed. And if he says something about this, then the defense witnesses will be called for examination and for the record. After the record of these sentences, the stage of final argument will be called before the court. In this final argument, both the plaintiff and defendant will be argued finally, and after the finally, the judge will come on the stage of final hearing. Now, this is the first stage. Now, the second stage one is when the accused is arrested on the spot or very soon after the commission of the crime. There are two situations. After the arrest, within 24 hours, the police is bound to produce him before the court, before the magistrate, and he will call for the judicial remand of 14 days. And the procedure of investigation will go on. And if the investigation is not completed within the time of 24 hours, the police will produce him before the court and ask for the PCR, police custody remand. And after this is the one procedure. And after that, when the investigation will be completed, the police shall file the charge sheet before the court. And after the presentation of the charge sheet, the same procedure which was in the case of the accused was not appear before the court will be same. The court shall take the cognizance, and after all the file will be go into the evidence, the record of chief, and after the record of it will be go under section 313 of CRPC, where the defense will be asked whether the accused whether you admit your offense or not, and after that the final argument and the final sentencing. These are two situations. Suppose a situation where the person has absconded and there is no any knowledge about it, and there is no presumption that he will come very soon in the future. The court will start the proceeding of section 229, in which the court will allow the state council to record the chief examination in chief, the witnesses of plaintiff, and after that, if the defendant is arrested in the police station, the police shall register his arrest in the general diary, and that general diary shall be sent to the court, will be attached in the charge sheet. After the charge sheet being submitted to the court will take the cognizance, and the same procedure will be. And during this, if after the record of the examination of chief, if the main witness dies, the existence of section 32 of the Indian Evidence Act will be come into force. That statement will be declared as the dying declaration, and all we know the relevancy of the dying declaration. The decision shall be final on the basis of that dying declaration. Here, the court has the discretion. If the accused ask for the cross examination, the court has the discretion either to allow the cross examination or not allow the cross examination. This is the thing. To which I was here to talk, and these are the things. Okay, now I have closed myself.
Thank you,
Thank
sir.
you so much, sir. Thank you. It was indeed a great learning experience for all of us. I, Shambhavi Singh, the moderator for today's event, on behalf of the organizing committee, would like to thank both our speakers who deliberated upon the subject and shared their insightful knowledge with us and sparing their time for this event to make it a success. Thank you so much, sir.
Shambhavi, please invite the questions, if any.
Yes, sir. Now I would. Anybody who has any question can ask, or
This
can
chat
write it
box
on the
also.
chat box. Do you have any question to ask? I think that brings us to the end of the event. So for that, I'd like to call Priyadarshini ma'am, who will be giving the vote of thanks. Ma'am.
Thank you, Sambhavi.
You're welcome.
Good evening, everyone present over here. I, Priyadarshini Tiwari, on behalf of JEMTEC School of Law, would like to extend my heartiest gratitude towards the eminent speakers of the day. Firstly, I would like to extend my heartiest sense of gratitude to Prof.Dr. N.K. Behel, sir. Thank you, sir. Thank you for being with us and enlightening the students with your kind words of wisdom. Thank you, sir. Further, I would like to express a deep sense of gratitude to Advocate Ajay Kumar Yadav, sir. Thank you, sir. Thank you for
Thank you.
sharing a very practical
Thank you.
approach with my dear students. Further, I'm thankful to the HOD School of Law for giving us an opportunity to conduct such a wonderful event. Last but not the least, I would like to extend my vote of thanks to the moderator of the event, Ms. Sambhu Singh, and my dear students. Thank you everyone. Thank you so much.
Thank you, Ajay
Before
ji. Thank you again.
Thank you,
sir,
sir.
before
Thank you
leaving the
very much,
session,
sir.
sir, I will request to every participant and respective speaker, please switch on their camera for group photo.
Sure.
Everybody, please kindly open your cameras.
Thank you, sir.
Thank you,
Thank you
everyone.
so much, sir. Thank you.
Okay, thank you.
Thank you, sir.
Student, there are link for the feedback form in the chat box. Please fill the feedback form.